An evaluation was ordered. The hearing in June of 2016, at which point Mr. Durkee apparently testified that he did not want Wendy to be appointed as his guardian. Evan Punderson, I'm not sure who he was representing, reported that an investigation by APS and neglect by Wendy was unsubstantiated. Okay, OPS wouldn't take the case. An appointment of guardian was done. It doesn't say to whom. License to sell filed by Ms. Durkee. A log skidder was given permission to sell in 2016. I don't know whether it was sold. Ms. Durkee was having trouble getting access to his bank account with Merchants Bank. The order here says Wendy Ann shall file an inventory and there will not be an annual accounting due since she doesn't technically have anything to do with his funds. That was in 2018. She failed to file a personal status report. And she appeared at a hearing on the failure. And I can't tell whether anything happened. It's noted on January 2, 1920, that Ms. Durkee had called to let the court know that her father had passed away. There was a request that she filed a closing report and a copy of the death certificate. I can't tell whether that was done. Let me just look over here. The will was filed in 1020. I can't tell, so we'll have to pull out that file. However, it looks like she was not in charge of his finances. I would need to look and see whether she actually sold the log skidder, which was, she was given permission to sell that to cover back taxes. Or I can ask Ms. Durkee. Ms. Durkee, did you sell the log skidder?
No, ma'am. It needed to have the piston put in and was not drivable and was on my dad's property. No one was willing to come and repair it with my dad there because he could be challenging. So my husband and I made up the difference between what my dad had.
So you paid the real estate taxes.
We paid about half. The redemption was $6,400, $65.34. We paid around $3,900.
Right. I will want to take a look at that file, but it looks like, it's interesting. It's filed as a voluntary, but I think it ended up being an involuntary guardianship. Looking at the
Dad decided he didn't need any help kind of partway through it, which was dementia, but.
Right, and I can't read the report by the evaluator here, because it's not, it just says a report was received. It doesn't say what it said. So
it was conducted at UVM Med, if that helps you.
It says it was done by Cheryl Bellman and admitted into evidence. So I have to look in the physical file, which is here at the courthouse. But in any event, the court, just for Ms. Packard's awareness, the court relieved Wendy of any responsibility for filing annual accountings in the guardianship. So that is not something I can undo or, do anything about. So we're going to move on from that.
Your Honor?
Oh, yeah, Ms. McKen, thank you.
Thank you.
I was looking down at the objections.
Mr. Scoville filed his fees. Should he be allowed to file? I mean, he filed with the executor, the administrator, as a claimant or creditor. Should he be contacted to ask him to give a sworn statement about, when he engaged with the client by letter, what the fee structure was? If he's denied, then, he has the right to appeal. So I'd just like to make sure that all the facts are in front of the court.
Yes, I mean, I find it hard to believe that Mr. Scoville would have agreed to do this pro bono. Our esteemed bar counsel, Mike Kennedy, certainly suggests that getting a fee agreement in writing at the beginning of a case avoids litigation of the kind that we're talking about here. So I think obtaining a statement from Mr. Scoville regarding his fees would probably be a good idea.
All right. Thank you, Your Honor. I'll write him a letter.
Thank you. Okay. So let's unmute Ms. Packard and hope that she can answer questions without interrupting.
She's unmuted.
Okay. Ms. Packard, I am looking at the document I think that you filed. Well, it's dated 7/14, okay? I'm trying to go through your document and make sure we have covered things. The Franzoni refund overpayment, they had to make an advance to him. Is that correct, Ms. McCann?
Yes.
And he refunded what wasn't used.
No, Your Honor, that was my mistake. I incorrectly read the invoice. So because Ms. McCann was his first client, he gave her a
Estimate?
Not a rebate.
A discount?
Yes, thank you. A discount. So I had looked at the raw figure before the discount and sent him the check for that. And then he refunded the difference between the discount that he had offered her and what his raw figure was, his
Okay. And so Ms. McCann, did you keep that?
No,
Or did you give that back to Ms. Durkee?
I think it was sent back to Ms. Durkee and she put it in the estate account.
Because it came out of the estate account.
Correct.
Okay, Ms. Packer, do you understand that now? I think that was helpful to have that explanation.
Yes. Going back to Justin Scoville for a minute, I have the email and the bill from him dated, which shows he didn't send that to me for 4 months, and showing that it was his first bill. Or not his, well, his first bill and his first time.
Filed that with the court, but already, if you haven't and you wish to file it, you can. Ms. McCann is going to reach out to him. Excuse me. She's going to reach out to him and get his letter regarding what the original agreement was. If the court feels like we need to have a short hearing with you and Mr. Scoville to discuss that, we will schedule that. But, you know, I'm trying to move this case along, and the court's calendar is